Então, se a gente instalasse aparentemente, nós temos grandes condições de estruturas para vários biomas. Isso é o simbolismo. Uma pesquisa de um bom dia para fazer. História. Vai sair um relatório dele, do Pantanal. Do senhor. Não, é você. Que é mérito seu. Eu só dei a ideia. Escuta, o presidente da Amanso.
Oi. Não. Oi, som. Oi. Oi. Hã? Vai lá. Oi.
Então você quer. Então vou ter que ligar o transmissor de.
Fala lá na cabine pra nós. Som 10. Oi. Oi.
Oi, oi, chegou? E oi, 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 teste, oi, I, teste, show,
Oi. Oi. Som.
tô escutando, eu escuto você, eu escuto.
Agora vai.
Som, som,
Is here.
som. 1, 2, 3, teste. Sound checking. Tá chegando na transmissão?
Só explica pra ele. Ele vai.
Inglês. Esquecemos da tradução. Colleagues, we will get started. Please grab your sandwich and anything that is available there. It's not much. It's a Franciscan sandwich and refreshments. It is with great pleasure that I open this special event on migratory species, law, and judges. It is the first time that in a COP of CMS we have such an event. I am Antonio Herman Benjamin. I am the president of the Global Judicial Institute on the Environment and the Chief Justice of the National High Court of Brazil, STJ. The STJ has national jurisdiction. We receive appeals from 27 state Supreme Courts and 6 Federal Court of Appeals. I begin thanking the partners, and we have several excellent partners in the organization of this event. Beginning with the Brazilian government, the Ministry of the Environment, the Deputy Minister of the Environment, my very old friend, João Paulo Capobianco. We have known each other for 40 years. And he is one of those people that know about law more than those that have studied law in law schools. The most, and no. It's not because of friendship. We should not mix friendship with merit. Merit is one thing, friendship apart. One of the most revolutionary pieces of legislation, not just in Brazil, but globally, and innovative for the protection of forests, was mainly drafted by him. It's the Atlantic Forest Act. When he started working on this, what we were able to achieve was a presidential decree, Decree 750. And I was part of the discussion in which he came with those very creative instruments and classifications of Atlantic forests that frankly I thought that would never become law. And it did. And nowadays we have hundreds or thousands of judgments around the world protecting the Atlantic forests based on that specific law. It's not a minor achievement to be a legislator without being in parliament and to be a legislator without having a law degree. But law is about science too, and it's about being rational and understanding the facts and understanding science. So many things. You probably all know that his nickname is Capo. Many thanks, Capo, for all the good work that you have done. And I'm sure that this is you now as president of the migratory species process, you'll be delivering much, much more than you have done in our own country. The second person that I would very much like to thank is Amy Frankel. I also know her for many years. She is a lawyer, but he is the opposite. He's a lawyer that understands Capobianco for your opening remarks.
Wow, it's a great honor to join this discussion under the leadership of the Minister Herman Benjamin, whose long-standing commitment to environmental protection and to strengthening the whole of judiciary has been truly inspiring, not only in Brazil, but globally. Migratory species are, by their very nature, a powerful symbol of interdependence. They remind us that ecosystems, like the challenges we face, do not stop at national borders. Birds, whales, and other migratory animals connect continents, oceans, and legal systems. Their survival depends on our ability to act collectively. This is why the rule of the law is not an abstract concept in the context of environmental governance. it is a fundamental condition for effective implementation of international agreements, including CMS, as a legally binding convention. Protecting migratory species goes far beyond formal subscription to an international environmental convention. These species cross multiple jurisdictions, each with its own legal frameworks, institutions, and enforcement capacities. As a result, the effectiveness of the convention depends on coordinated, consistent, and legally robust implementation across countries. At the national level, the rule of law provides the foundation upon which environmental policies are built. It ensures legal certainty, regulatory predictability, and accountability for environmental harm. Without these elements, commitments risk remaining only on paper. To effectively protect migratory species, we need clear and enforceable legal norms, strong and well-equipped institutions, and the capacity to monitor, control, and enforce compliance. This is where governance becomes tangible. Within this framework, the judiciary plays a decisive role. Judges, like Herman Benjamin, are essential in ensuring that environmental are not merely symbolic, but effective. They act to correct omissions, address failures in public policy implementations, and safeguard diffuse and intergenerational rights that belong not only to us, but to future generations. Moreover, judges, as Herman Benjamin, are key interpreters of the law. In environmental matters, report of the state of a migratory species launched by CMS Secretary at this COP. As we have to say thank you for this very, very important report, Amy. Very, very important report. Migratory species are being pressured simultaneously across multiple countries along their migratory routes, habitat loss, fragmentation, and ultimately disrupt nearly 1/4 of the CMS listed species are threatened by extinction, and almost half are experiencing population declines. We are witnessing sharp declines in migratory birds across multiple global flyways, the collapse of migratory freshwater fish populations, and dramatic reductions in sharks and rays, with global abundance declining by around 50%. 50%. So the role of law and judges are essential to ensure that our commitments translate into real lasting protection for migratory species and for the ecosystems on which our life depends. Thank you.
Thank you very much. The numbers are there. We cannot say that this is vague, that we judges need to guess. No, the numbers are there. It's my pleasure now to invite Amy Franco for her opening remarks.
Thank you so much, Antonio. And I want to say I feel like I'm home now. Usually when I'm at a CMS event, I introduce myself by saying, I'm a birder, I'm a diver, I'm a hiker. But now I can say, I'm a lawyer. And I invite all of you non-lawyers to our world of international environmental law. And I'm a proud lawyer. I really appreciate, as Antonio mentioned, I've known him and then have treasured our friendship for many years now. I think we're getting into the 2-decade mark at least. When I worked at UNEP actually, and then later CBD, and now at CMS. And I am so thrilled to see your initiative to bring your wonderful work to CMS, to bring it to CMS, to bring CMS into your world and your innovative work with judges and lawyers, because we need that. We really do. So I hope this is the start of a beautiful relationship that we can continue following the COP, first off. I want to actually build on what our COP chair, Capobianco, started with, which is the threats, because we need to translate those into the law. And actually, I think it's very straightforward how we can do so. So we look at the threats that we've identified based on science. Overexploitation, which includes hunting, intended hunting, capture, fishing, but also bycatch. We look at destruction of habitat, destruction of or fragmentation. We look at climate change, pollution, as well as invasive species. So how do we translate these into legal obligations? I would describe these as first direct approaches and indirect. So in terms of direct approaches, the treaty itself, CMS, is a very special treaty because we were one of the early ones that was adopted following the watershed Stockholm environmental meeting in 1972. And this was at a time when lawyers were thinking, pollution is going beyond our borders. What do we do? How can we bring other countries to the table so we can cooperate? Out of that conference in 1972, one of the actions was we need a treaty on migratory species because they cross international borders. And I have seen a photograph, by the way, with Justice Benjamin in it very early on when Brazil was talking about joining CMS. So I'm it's like bringing all these pieces together. That treaty was also developed with the support of the IUCN Law Commission, and at the time it was Wolfgang Berhena and his wife, who many of you know, who were really incredible leaders in the 70s and beyond on this. So there's a lot of history here. And having the convention in Bonn where they were is also, and where John Scanlon, by the way, is now the head of that group that he started. So all of these things are kind of coming together in a beautiful way. But CMS is a very simple concept, which is if there are species that cross a border, we need to then work across that border to protect them. It is one of the few legally binding treaties on environment under the United Nations. That's a big deal. It's legally binding. It's different than the CBD, which it's more of a policy instrument. And my colleague and our legal officer, Maria Jose Ortiz, will speak later about the specifics of what that means. But let me simply say, the strongest legal obligation is that range states are not allowed to kill, to take, to capture species that are listed under Appendix 1 that are in their range. Now, importantly, just a little side note that's very important, however, This includes on the high seas, okay? And we already have jurisdiction on the high seas. If there is a ship, a flagship is flagged to a country, and it's fishing and it's killing a protected species under CMS, that's a take under CMS. So we are already at the table under the BB&J, and we've made that point there strongly. So we need to continue our work there. But coming back to CMS, under Appendix 1, there's a prohibition on taking of species with some exceptions. There's also some additional softer but related language about if a species is on Appendix 1, you also have to look at other threats like habitat destruction and so forth. The biggest obligation as a country under CMS, a party under CMS, is to have domestic legislation that interprets and applies CMS. Such legislation can actually help avoid the silos that exist, because there's CMS, there's Ramsar, there's CITES, which deals with the international trade, CBD, as well as other domestic commitments. National legislation can integrate those. And so, national legislation can deal with, for example, bycatch, which under CMS, it's been, you know, we're working on it without defining it or not defining it as taking. It is something that is, I won't get into the details now, but, you know, there's a history about why it's like that in the treaty language. But at the domestic level, obviously, there's lots of rules on bycatch that can be enforced. In addition, unsustainable taking, and I just walked off the podium in the conference committee of the whole where that's being discussed. If taking is at levels that are unsustainable, then at domestic legislation that can be addressed. Okay, so there is so much that can be done through the sort of what I call the direct approach. Two last comments in terms of the indirect approach. There are so many other laws that you can bring to bear in a country like Brazil or all over the world that are relevant to commitments and the threats that we deal with under CMS. For example, infrastructure. There's been years of work looking at environmental impact assessments were one of the first legal obligations of countries that were looking at environmental law. The National Environment Policy Act of the US in the 70s was one such law, and UNEP used to play a role, by the way, in getting that kind of body of law into countries around the world. That can be enforced. That can be enforced against infrastructure that's being planned without thinking about habitat, without thinking about if this is a critical site for these species. And so that's how you can enforce it. Safeguards, environmental safeguards that have been adopted by the World Bank, by all of the international financial institutions, and many governments follow as the standard. Those can be enforced. So there's many, many other ways. I'll also mention climate change, which of course is very interesting, what's happening in the ICJ and at the domestic level. And finally, pollution laws. Pollution is a huge threat to species, and looking at domestic laws that deal with that, including chemical, lead ammunition, which the EU, by the way, is working on and has adopted some regulation of, chemicals, plastics, noise, and sound, and light pollution are all things we have to deal with. So I invite all of you to really be thinking outside the box, both through the direct implementation of CMS, as well as these other ways of using domestic law to achieve the objectives and the needs of CMS. The last thing I'll say is that, and we just got strong support from the room, and I'm thrilled about this because I personally invested a lot of work on it, and it is that link between the science and the law that you mentioned that actually really touched me, because that is how I operate. And what we learned is that one of the greatest threats to migratory species has kind of been under the radar, which is this pressure in the inside countries that of species that are not traded internationally. There are many issues around international trade, but lots of species are not traded internationally. And we have ignored this. We have got to get our hands around this. So we are launching tomorrow, and we hope you will join us, a special new initiative on the global taking of species, of migratory species. It is absolutely essential that we address this and elevate the attention that is essential for sustainable development. It's also essential for legal trade, because if we keep putting pressure on these species domestically, there won't be anything left to trade. So this is something we have to do holistically. And again, countries are the best place to do it, because they're the ones in the driver's seat in terms of the domestic, bringing these things in harmony and taking a much more holistic approach to these issues, so that species are not, well, that's that treaty, that treaty. So this is where we look forward to working with you as the COP presidency, Brazil, after the COP, and everyone else on this initiative, and through our national legislation program that I know Maria will be talking about later. So thank you, obrigada from my heart, and thank you to the government of Brazil for convening here so we could talk about this. Thank you.
As you can see, the welcoming remarks in this opening session are not just platitudes. Many thanks for everyone for being here and this and that, you know, I'm beautiful. No. We talk about substance right at the welcoming remarks. You mentioned the threats, and that's exactly where judges should focus on. It's not post factum. The damage is done, and then we arrive. Because some of the damage cannot be repaired. And among the major threats, you mentioned overexploitation and habitat destruction. The reason why we are circulating this brochure, the Model Forest Act, is precisely because we understand that without the protection of habitat, we'll go nowhere. Of course, overexploitation is terrible, but if you keep the habitat, you might reintroduce species that have been saved ex situ. But if you destroy habitat, often it is impossible to bring those species back. Therefore, we need to protect vegetation. Of course, this is more on the terrestrial aspect, but the oceans as well. There will be a whole session in a minute about the general part of the Model Forest Act. You also mentioned the moment when Brazil joined CMS. And I tried for many years. I would go to the Ministry of the Environment, and the Minister of the Environment would say, well, it's Itamaraty that is responsible for this. Itamaraty is blocking. I would go to Itamaraty, Itamaraty says, no, it's not us. It's the Ministry of Finance. So I would go to the Minister of Finance, and he would say, I'm not even aware of this. So I called Elizabeth Mirema, who is sitting here in the front row. I said, Elizabeth, I need you to come to Brazil, and I'm going to take the chief diplomat. Nowadays, our ambassador in Egypt, Paulino de Carvalho Neto, was the head of the protection of nature within the Ministry of the Environment, and we go, not to a bar, we did go to a bar, but we go to the Amazon together, and we did. And Paulino was then enlightened about the importance of this convention, and that's how Brazil joined. So many thanks to Elizabeth Mirema and also to Ambassador Paulino de Carvalho Neto. The next speaker is a force of nature. I think the best way to describe her is it's a combination of the Nile, the Congo, and the Zambezi. You could add the Amazon River too, and you would have this fascinating person, Dr. Muzonda Mumba, who is someone that can speak about anything, but especially about her passion, which is wetlands. We are very pleased that she is joining us here in this opening, because once in October we deliver the Model Forest Act, I have a new project. And the new project that I have already shared with her is called the Sources of Life. To get the 10 biggest rivers of the world and use them, as we do with the charismatic fauna, Braulio, the panda, the tigers, in order to enlighten people, but also policymakers and judges about the need to protect the sources of our river basins. The tiny streams all the way up to the Amazon, the Danube, the Rhine, the Congo, the Nile, the Zambezi, the Ganga, the Yangtze, the Mekong, and the Brahmaputra. If we bring together those rivers, and in China, 3 of those have their sources in one area that's smaller than one of our smallest states. Imagine this, on the top of, and then we have the Ganga also in the Himalaya. And that is my next initiative. And I didn't need more than 1 second to convince her that this is something that we should do together with Ramsar and the other and all other partners, to use the charismatic rivers and their sources the way we do with the charismatic fauna in order to enlighten people. So many thanks, my dear colleague. It's my pleasure to invite Dr. Muzonda Mumba for her welcoming remarks.
Thank you very much, Judge Benjamin, and really such an honor to be here in Campo Grande and the president of the COP. I'm really, really excited. I'm going to be a little bit provocative. Wetlands are the foundations of the hydrological cycle. And many wetlands, including here on this beautiful continent of the Latin American region, they start from glaciers. Now, we have 2 Ramsar sites that start in glaciers in Switzerland, where we are based as the convention. And for many countries, even island states, wetlands has been really about water. Water supply and water to drink. But as my dear friend Amy alluded to, this aspect of pollution. Now, I have a sister of mine who is a judge in Zambia. And I remember one time talking to her about the wetland, the Ramsar site in Zambia where I did my PhD, where, you know, there's some mineral extraction that is going on. And she was like, oh, I didn't realize that this is happening. Similar to what you just said. Now, my provocation is to say this. I think we do not have a lack in legislation. For many countries, I think what has been a failing of bridging and synergies so that judges, the law, understand what all of our MEAs do together is fundamental. Nature doesn't know today, is it CBD day? Is it Ramsar day? Is it CMS day? Nature exists in a very holistic way. Now, one of the things I want to say is that, and law is about people, as wetlands are about people. And because they're about people, we also have to recognize that even with good intention and good legislation, sometimes they can come unraveling because of changes in governance systems, governments, political processes. What do we do then? And so who should we bring to the table to be able to say, if this is undone, we are done for? What we're facing in the world is the loss of wetlands, which are getting lost 3 times faster than forests. And I showed a picture in the high-level segment of the Aral Sea, which has been lost in our lifetime. But because of good legislation across Central Asia, even the Saiga antelope, which is part of the CMS, has recovered. And it is through this recovery and this conversation and synergies across conventions that has made it really possible. And I just want to close by saying that what is really incredible, and really thank you for your leadership, is that many legislators, and I was very fortunate to meet a senator who flew all the way to Switzerland, Senator Uresti from Chile. He came to see me and said, "Ma'am, I want to let you know that we are putting through a legislation on wetlands on wetlands in cities, wetlands in urban spaces." This morning I went running in Campo Grande, in the Lagoa de Parque, beautiful wetland in the city of Campo Grande. And for many people, we do not realize that if this is not designated, the city is not cooling well enough. We are living beyond a 1.5 degree world. And wetlands and forests are the system that really are keeping us cool and really in a livable planet. But colleagues, without laws that really are protecting the very planet we call home, Mars is too warm to live on. And this is the one planet that we call home. So I'm really excited that there are conversations happening here at CMS that really bring together the convergence of why our work and law and judges in particular are and will be instrumental to how we protect our planetary boundaries. So I wish you all the best, and I'm looking forward to the discussions and really just interacting with colleagues and learning a lot more. I'm not a lawyer, I'm a wetland hydrologist, so I come from the science, but I'm excited to see that these two worlds are really converging in the most powerful way. And thank you very much for this invitation to give my opening remarks. Muito obrigado.
Many thank yous. We are now approaching the closing of the closing session, and it's my great pleasure to introduce the Chief Justice of the Supreme Court of the State of Mato Grosso. Justice Dorival Pavan is someone that I admire very much. É alguém que eu admiro muito. It's someone that does not hesitate. É alguém que não hesita. The worst judge is one that hesitates, not to think over, to meditate, but just not to act. O pior juiz é aquele que hesita, não para meditar, mas simplesmente para não agir. And he fully understood the importance of this COP in the land of the Pantanal, and that the judiciary, the state judiciary, had to join forces with the good people that came here. E você entendeu a importância de trazer o judiciário aqui para a COP. So it is my pleasure to invite the Chief Justice of South Mato Grosso for his opening remarks. I asked Professor Nicholas Breiner, who speaks Portuguese better than me, especially when I am tired like now, to be the interpreter. He speaks Portuguese beautifully and fluently, flawlessly. Com a palavra, o presidente do Tribunal de Justiça do Mato Grosso do Sul.
Muito obrigado, ministro Antônio Herman Benjamin. Eu cumprimento ao senhor, ministro Herman, ao ministro Paulo Capobianco, que gentilmente, na condução dos trabalhos desta 15ª COP, gentilmente ceder um espaço para o Tribunal de Justiça de Mato Grosso do Sul poder participar e se integrar com as ações, as discussões que estão sendo travadas no âmbito dessa COP15, envolvendo essa temática fundamental da sobrevivência, não só do ecossistema, mas do próprio homem.
Thank you. Thank you, and my sincere thanks to Justice Benjamin and to the President of COP15, Minister João Paulo Capobianco, for giving me the opportunity to speak on behalf of the Supreme Court of the state of South Mato Grosso during this important event.
Ok, thank you very much. Nesta 15ª COP, eu saúdo também Amy Frankel, Christina Park, né, e doutora Muzonda Mumba, que também se fazem presente à mesa, muito agradecido até pelas manifestações anteriores.
And I recognize also Amy Frankel from the CMS and Dr. Musonda Mumba and the others who have spoken at this panel.
Nesta 15ª conferência, nessa reunião da Conferência das Partes da Convenção sobre a Conservação das Espécies Migratórias, nós ouvimos falar muito sobre aspectos fundamentais para assegurar os corredores de migração das espécies e de seu núcleo fundamental de preservação de um meio ambiente ecologicamente equilibrado e sadio.
During this 15th Conference of the Parties on migratory species, we have heard a lot about the fundamental aspects for ensuring corridors for migration for species and the importance of preserving an ecologically balanced and healthy environment.
Ouvimos muito falar sobre os acordos multilaterais, sobre a conectividade, sobre a responsabilidade. Migrações apontam para a dependência da sobrevivência das espécies para habitats distantes, e isso implica diretamente em impacto desse processo migratório entre as diversas nações.
We have heard a lot about the importance of multilateral agreements, about connectivity and responsibility. Migrations point and demonstrate the dependence that species have to survive on the protection of distant and a variety of habitats. And this directly implicates the process for migration among many different countries.
A pergunta é, dentro desse segmento que nós estamos discutindo, qual é o papel do Poder Judiciário para se integrar plenamente nas ações desenvolvidas pelas altas partes contratantes e contribuir efetivamente para a preservação das rotas migratórias e dos animais silvestres que dela dependem e que todos aqui reputamos necessárias? Qual é o papel da lei e dos juízes nesse processo?
So our question is, what is the role of the judiciary to get involved fully in developing actions from the parties to the convention in order to contribute effectively for the protection of migratory routes for wild animals that depend on us? And what is the role of the law and the role of the judges?
O Poder Judiciário, como nós sabemos, ele não age de ofício. Mesmo que esteja ciente de uma ação predatória que coloque em risco não só as espécies, como todas as demais da fauna e da flora. Ele precisa ser juridicamente acionado para atuar.
The judiciary is constrained somewhat in that it cannot act on itself. The judges must wait, even though the judiciary might be aware of actions that put species at risk, we have to wait until a case is brought before us in order to act.
O que eu quero destacar, na realidade, é a atuação do Poder Judiciário, e o ministro Herman Benjamin até se manifestou aqui, nas questões relativas à atuação do Judiciário apenas na composição dos danos. Mas o Judiciário, ele não deve atuar apenas no sentido de querer combater e punir os danos já verificados.
So what I want to emphasize is about the role of the judiciary in providing remedies for damages. And the role of the judge should be more than just looking to the past and trying to figure out and provide a remedy for things that have already occurred.
Nós temos uma legislação brasileira, a partir da Constituição Federal, no seu artigo 225, que estabelece que é dever do poder público e da coletividade a proteção ao meio ambiente. E essa proteção ao meio ambiente e dessa coletividade deságua também na legislação infraconstitucional, e o Brasil é rico na legislação infraconstitucional, o ministro Herman que eu diga, é rico na disciplina de preservação, de combate às medidas ou às ações que impactam diretamente o meio ambiente.
Brazil's constitution in Article 225 recognizes the constitutional right to a healthy environment, but also the duty of the people, the collective duty of the people. And what is that collective duty in terms of preserving the environment?
Por isso que eu penso que o judiciário, ele não pode atuar apenas e tão somente quando o dano já ocorreu. É de fundamental importância, o ministro Herman também salientou isso anteriormente, é de fundamental importância que o judiciário atue preventivamente. E esse preventivamente, felizmente, no Brasil, como em muitas legislações, nós temos previsão jurídica para que o juiz possa atuar preventivamente no combate àquele dano ou aquele possível dano que é noticiado com a ação trazida em juízo. Nós temos uma disciplina.
So it's critically important that the judiciary act proactively and not simply wait until the damage has already occurred. We have the responsibility to act proactively and when we identify that damage may occur or is about to occur.
Nós temos uma disciplina que está instituída no nosso ordenamento jurídico que se chama tutela de urgência. Ou seja, se o juiz toma conhecimento de uma determinada medida, de uma determinada ação, e a probabilidade do direito e o risco de ineficácia do processo ao final, aquilo que nós chamamos de o processo ser inútil quando finalmente for concedida a tutela, o juiz não é que ele pode, a meu modo de ver, preenchidos os requisitos, ele deve atuar para combater eficazmente aquela atuação que vai impactar significativamente o meio ambiente em relação ao fato que lhe é apresentado.
And so we have a procedural device that the courts can use called the tutela de urgência, the judgment of urgency, where the court can act when there is an imminent risk of harm and in fact has the duty to act when the court is aware that damage may occur to the environment.
Ou seja, nós temos os instrumentos legais. Eu penso que os outros países também o têm. Essa interconectividade que nós falamos também nas relações institucionais entre as diversas nações, permite concluir que esses instrumentos também existem. Mas aqui, o mais importante, além disto, é nós termos juízes preparados, vocacionados para agir preventivamente.
So we have the legal instruments in order to be able to do this, and I'm sure that other countries also have similar legal instruments. But what we really need is judges who are willing and dedicated and committed to act preventively before harm occurs.
O Brasil tem uma das maiores cargas de processo do mundo. Nós temos pendentes de julgamento aproximadamente 80 milhões de processos. E nessas 80 milhões de causas se inserem também as causas do direito ambiental, as causas ambientalistas.
The Brazilian judiciary has a great weight of 80 million cases that are pending before the Brazilian judiciary. And so among these include many that have to do with the environment.
Bem por isso que eu tomo como modelo e paradigma o ministro Herman Benjamin. Ele é um presidente do Superior Tribunal de Justiça, mas ele está presente na COP desde o primeiro momento. É um ambientalista, é um estudioso de direito do consumidor, é doutrinador e é também um formador de opinião através da doutrina que ele prega e da jurisprudência que ele edita sob sua relatoria no Superior Tribunal de Justiça, e aqui o importante, que não se acomoda, é inquieto. E o juiz deve ser assim também. Ele não deve ser acomodado, tem que ser um juiz inquieto, um juiz estudioso, um juiz preocupado com as questões que lhe são colocadas, inclusive, notadamente, as questões ambientais. O juiz não pode, depois de ter sido provocado, permanecer passivo. O juiz que não decide é o pior dos juízes do mundo. O juiz tem de decidir, bem ou mal, ele tem que decidir, notadamente nas ações e nas causas que envolvam o direito ambiental, que necessita de uma tutela de urgência pronta e imediata para coibir o dano que está prestes a acontecer.
And so I look to Justice Benjamin as a reference, as an example to try to follow. As a judge, yet he is here at COP15 maintaining an active presence, because it's important for the judge to act, and the judge needs to decide. the worst kind of judge would be the judge that only receives information and never decides.
No Brasil, felizmente, nós temos a Escola Nacional de Formação e Aperfeiçoamento de Magistrados, nós temos as escolas judiciais que preparam e formam juízes. E esses juízes se preparam para o exercício da judicatura. Mas é necessário mais, é necessário que as escolas possam fomentar o estudo do direito ambiental, porque ele envolve diversas matérias diferentes entre si, que se convergem para um ponto comum, que é o próprio direito ambiental, e o juiz tem que ser um fomentador, um conhecedor dessas várias matérias que se conectam e que possam resultar no direito ambiental para aplicá-lo e aplicá-lo bem.
Throughout Brazil, we have judicial schools and judicial academies and training centers that provide education for those who are entering the career as judges. But we need more than that. We really need these academies and schools to really provide the foundation and really incentivize judges to think and study the environment so that they are prepared to handle environmental issues.
Ok, esse é o principal ponto. Um juiz que estuda, um juiz que se prepara, um juiz que decide preventivamente, um juiz que decide bem e que decida em tempo recorde, em tempo rápido.
So these are the main points: the judge that studies, the judge that understands, the judge that is prepared, and that decides preventively before the damage occurs.
Nós asseguramos aqui simplesmente esse equilíbrio e garantia entre as diversas forças que se opõem para que os postulados básicos do direito ambiental possam ser efetivamente aplicados no nosso ordenamento jurídico e, com isso, nós tenhamos decisões que possam fortalecer todo o sistema ambiental na proteção mediante as decisões judiciais que são assim tomadas. Muito obrigado.
And this is the key, that we have judges who are willing to really focus on the foundation in order to ensure that they make good judgments with regard to the environment.
Dentro dessa, somente para finalizar, dentro dessa ótica que nós estamos falando aqui, da preparação do judiciário para essa finalidade, eu tenho a honra de anunciar, por provocação do ministro Herman Benjamin, que é, na realidade, o grande autor da ideia, mas que nós aqui adotamos sem dúvida alguma. Nós estamos em Mato Grosso do Sul, Campo Grande, capital, porta de abertura do Pantanal Sul-Mato-Grossense. As questões ambientais aqui também existem. E com isto, o que nós estamos propondo e vamos fazer? A criação de uma vara especializada em direito ambiental do Pantanal, envolvendo...
And so I'm only to conclude, but I'm very pleased to announce that here in this region in South Mato Grosso, that we are proposing the creation of a specialized environmental court for the Pantanal.
Essa vara de direito ambiental ficará sediada em Bonito, que é uma das cidades componentes do Pantanal Sul-Mato-Grossense, e nós teremos a honra e o privilégio de darmos competência para as questões ambientais, as correlacionadas ao direito agrário também, enfim, uma vara que venha, a primeira delas, né, ministro, se Deus quiser, para enfrentarmos realmente da forma como devem ser enfrentadas as questões ambientais no Pantanal Sul-Mato-Grossense.
The court will be located in Bonito, which is one of the cities here in South Mato Grosso that are important for the Pantanal, and we look forward to that court will have the power to address environmental matters as well as agrarian and other related cases.
Eu queria agradecer. In English. I would like to thank, first of all, Professor Nicholas Breiner. I forgot that he would be speaking English. He would not be translated from English into Portuguese. Yeah. So the fact that he speaks fluently Portuguese is irrelevant. He speaks better English. But the most important piece of news in this conference on the domestic side of things, and that's where the conventions come to life, has just been given by the Chief Justice of South Mato Grosso. And you see the importance of the judiciary. Just because he announced this, the Attorney General of South Mato Grosso, and I would like to pay a tribute to him. Our colleague Romão Milhan has announced that he will also be creating a special environmental prosecutor for the Pantanal, based in Bonito too. So it's a good domino effect that we have here. And many thanks for CMS for allowing us to make this change. And once South Mato Grosso does it, Mato Grosso North will do too. And then we are going to have the Pantanal with judges and prosecutors dedicated just to the protection of that extraordinary and irreplaceable biome. So many thanks, Chief Justice. This is the best news we could get. With this, we close this sort of long opening, but as I said, not an opening of platitudes, an opening with substance and with results. And I immediately invite the chair of the next panel, our colleague Vivek Menon. Vivek is the IUCN Species Survival Commission chair, but most importantly, he's the wildlife ambassador of India. And he does this pro bono. So Vivek, please take your seat here. I will also invite my colleagues, Elizabeth Mirema, the person responsible for Brazil joining CMS, and our colleague Maria Jose Ortiz, and John Scanlon has recorded a short video. So from now on, we have to be concise in order to make sure that we cover the whole program.
Thank you, Justice Benjamin.
Please, here.
It's okay.
Muito obrigada.
Obrigado.
Hi. Welcome. Okay. Let's start with this announcement that Justice Benjamin has just passed on to me. Friends, this is being broadcast live on YouTube, so all of you can tell your friends who can't be here that they can watch it now or later, and all of you can be prepared to look good as this live stream takes you across the world as well. Okay, friends, I'm very, very happy to be here for several reasons. Reason one is my friend Justice Antonio Benjamin has been very kind enough to bring me here and put me before you. But he just said that I should keep friendship totally aside from merit. And so, Justice Benjamin, I would like to, I do want to say the saying that in Brazil, he cannot take suo motu cognizance. Well, in India we can, and our judges do. They read the morning papers, as Justice Benjamin was saying, and here in the afternoon, a case of national importance. All public interest litigations, including environmental litigation, can be taken suo motu by the Justice of India. So the judges who interpret the law, so the law is important, but the ability to understand it and interpret it and pronounce on it is something that India has taken very seriously. The report that I co-authored about 17 years ago on the corridors of India has been implemented more by the judiciary than the executive. As the executive is trying in 17 years to declare parts of the corridors as protected, the judiciary has said we don't need the protection under law. We are declaring that these areas, as is there in this landmark report, shall be protected for the movement of elephants or tigers or other wildlife. So a proactive judiciary is indeed extremely important for all of us. I don't want to run out of time. We have two formidable speakers on either side of me, and John Scanlon, who has sent in his address as well. So let me, without further ado, introduce you. Well, you don't need an introduction, I don't think, to Elizabeth Mrema, who is the all-rounder of the United Nations in terms of environmental protection. She has run this convention for 4 years, if I'm not wrong, and the CBD, and I believe you run the Plastics Treaty now as well, or not yet.
CBD and CMS.
Yeah, well, I remember you did something else as well. Anyway, let me not get into that. But literally can chair any environmental international instrument with both her legal knowledge as a lawyer, as well as the ability, I think, I would call her an international diplomat for biodiversity over the years. So, Elizabeth, without further ado, may I pass on to you to give your remarks on this session.
Vivek, thank you very much for the introduction. I'm not sure I deserve it. But Antonio, sincere thanks first for organizing this event. Truly, probably, is the first one in the history of the convention, and I hope it's not the last one, because it is important now to also see really the judiciary actively participating in the protection of the environment. And for our purposes this week is the protection of the migratory species and the ecosystem that sustains these species across borders. And of course, Vivek has reminded us the additional flexibility that Indian courts and judges in particular have taken. And that's why we always go looking for those landmark judgments which go out of the, one will say, written law strictly, but basically, as you said, interpreting the law and taking the suo motu on their own to bring up matters and decide. I think that is very important. But it is also especially meaningful where we are, that why we are gathered here in Brazil. Chief Justice has already told us and why we are here, with literary courts being established for this purpose, for which I'm sure we are all really thankful. And of course, Brazil being the most diverse country on earth, one of the vital importance to migratory species, be it on land, or air, or rivers, or the ocean. Clearly why we are here, and we appreciate. And Brazil have enshrined environmental protection in its constitution, specifically Article 225, which says all, and I emphasize all, have the right to an ecologically balanced environment, which is an asset of common use and essential to a healthy quality of life. It didn't say human being, it didn't say birds, it didn't say fish, it said all. And if we take the India interpretation, it can mean all species, including human and others. So again, we can see where the law is already out there. Of course, one may say this is not a legal principle, but it is a statement of values, one that resonates deeply with the mission of the Convention of Migratory Species, CMS. We have been told over and over the last few days, and I'm sure it will continue the whole of this week, that the migratory species connect our planet in the ways that few other elements of biodiversity do. So really, this convention is unique. From birds crossing different continents, to marine species traveling thousands of kilometers across the oceans, to the mammals relying on the chain of inhabitants that span countries, regions, and literally the entire hemisphere. So clearly, nature does not know borders. And to protect these species, we actually also need to think beyond the boundaries, beyond the national borders. We need to look to strong environmental governance grounded in law and implemented through effective institutions. And today, strengthening environmental governance to protect migratory species and their habitats across the borders remain not only important, but actually urgent. We've been told of the state of the world migratory species findings, that we are losing almost 50% of all species listed under CMS. This is a serious matter and is actually a stark reminder that these, despite decades of efforts, and this convention has been on since 1973. I mean, 73, it is as old as UN Environment Program, so it's over 50 years. So us all as environmentalists, we should be ashamed that 50 years we are still talking of declining almost 50%. Something is not happening right. So delighted now the judiciary is also reminding us by coming on board to really help us to respond, where are we doing wrong? And it's not just the species declining, it's habitat loss, it's degradation. All these are the drivers of the decline. So protecting these species, protecting the ecosystem, protecting the wetlands is not an optional. It is fundamental for us to be able to maintain this ecological connectivity on which these species and ultimately all our life depend on. And the CMS holds a unique place in the global environmental architecture. Has already been indicated, not only that it's a global treaty dedicated to migratory species and their habitats, but also dedicated to us ensuring those migratory routes that link them are equally protected. And it is the treaty which provides the legal foundation for this coordinated conservation across the migratory pathways, bringing together countries to share that responsibility for species across the entire life cycle. But like all other international agreements, its effectiveness is what happens within the countries or depends on the countries. Because unless these international commitments are translated into national laws, are translated into policies and implementation frameworks, then they remain very good writing on papers. And to do so, of course, we also need to look at the integrated approaches, both internationally as well as at national level, to be able to guide the planning, the infrastructure, as well as the development decisions. And therefore, laws themselves will not be enough. And this is where environmental rule of law depends on institutions, and here in particular, the judiciary. The judges play a central role in making these environmental commitments real. It is through their interpretation, enforcement, and accountability that the courts can ensure that the laws are not just written, but they are actually applied. They give a meaning to the principles such as prevention, precaution, intergenerational equity, and also to ensure that ecological connectivity is not just treated as an abstract concept, but actually it is given a legal reality, that which must be upheld. And Brazil also has demonstrated the critical role the judiciary plays in advancing environmental protection. And recent decisions, just in this country, reaffirming indigenous rights, indigenous land rights to strengthening action against illegal deforestation are actually helping to safeguard the ecosystems and ecological corridors that the migratory species depend on. And this, of course, applies even in the context of this COP, which comes in at a critical moment, at a time when environmental materialism continues to deliver. Biodiversity cooperation, therefore, remains one of the strongest areas of international cooperation. We know 70 countries are now engaged in the CMS national legislation program, and maybe I'm sure Maria will talk more about that, so I should not get into her presentation. But what is important there, it clearly means that strengthening the laws will also means ensuring enforcement, and also means empowering institutions, including the courts, to be able to uphold them. The legal frameworks are particularly critical when it comes to protecting these habitats. And more important, the sites for the migratory species, which still lack legal protection. Scientific knowledge gaps persist, we know, and only about 52.6% of key biodiversity areas important to CMS-listed species are currently covered by protected or conserved areas. So this is both a challenge, but it gives us also that opportunity, that besides identifying these gaps, which allows the countries now to be able to act, but to designate the new protected areas, to restore degraded ecosystems, to reconnect fragmented landscapes become key, and particularly in our efforts where the forest plays a vital role. And later we will talk of this good document in front of us, the Model Forest Act, which I will stop talking about that. But let me go just to UNEP quickly as I finish. In UNEP, we have our Montevideo Environmental Law Program, which for decades, this program has supported countries in strengthening environmental law and advancing environmental rule of law globally. It brings together governments, experts, institutions to share knowledge, develop tools, and build and enhance capacity at national level. It promotes integrated approaches that link both biodiversity, pollution, and climate to ensure that environmental governance really contributes to the broader goals of sustainable development, human rights, and equity. So I know we'll hear more on how we engage the judiciary, but we also, UNEP, continue to engage with the Global Judicial Institute of Environment by supporting also judges in addressing these complex issues, that transboundary nature of environmental challenges. To this, the laws are only as strong as the institutions that uphold them, and judges are among the most important guardians of environmental future. Thank you.
Thank you, Elizabeth, for that wonderful exposition. We are short of time, so I'll move almost straight to the next speaker, who's not amongst us today. He's a man who has been at 3 or 4 CMS COPs running, John Scanlon, who hopefully is joining us live as well from wherever he is. He is the executive president today of the International Council of Environmental Law, but many of us know him as a former Secretary General of CITES or the principal policy advisor of UNEP at one stage, and even before that, the head of the environmental law program of IUCN. So he's worn many hats as well. So John, really sorry that you're not here with us, but we would like to hear your recorded message. So can the message be played, please? Can the video be played? Yeah, thank you. I hope you can see it over our heads. Coming on? Okay, all right.
I think, as you know, I would dearly love to be joining you in Brazil, but for personal reasons, it's not been possible. Now, I'd like to extend my most sincere thanks to Executive Director Amy Frankel and her good team, and to Chief Justice Antonio Herman Benjamin for bringing this special event together, as well as to all co-sponsors, session chairs, and speakers. It is an honour to be included in this august group. Now, our session is talking about a panorama of migratory species, law and habitat. And when we talk of a panorama, we're talking of a comprehensive big picture perspective. When we look at the CMS, like other treaties of the 1970s, they tend to target a very specific issue, be it migratory species, trade in species, sites of outstanding universal value, or wetlands of international importance. They are focused treaties that are regulatory in nature. And it is perhaps because of this focus that they have been relatively successful. But if we're going to take a panoramic view, we need to zoom out from the migratory species and look at the CMS and all of these other treaties I've referred to and the ones that have come since as a part of a rich, human-made international ecosystem of conventions, policies, and institutions. And this ecosystem of environmental treaties is nestled in a wider ecosystem that includes sustainable development, transnational crime, and human rights treaties. Now, back in 2019, when I was working as Special Envoy for African Parks, the connection between a real ecosystem and the ones we've created to manage and protect them really struck me. I was invited to speak at the Garamba Ranger Day at the Garamba National Park in the DRC. And while I was there, I got to see the great work being done by the rangers and many others in Garamba in conserving biodiversity, mitigating climate change, stopping illegal wildlife trade, protecting wetlands, and protecting the outstanding universal values underpinning its World Heritage status. And thereby they were supporting the implementation of multiple treaties. Now, as such was also evident from the recovery of chimpanzees, elephants, giraffe, and the safe haven provided for the 4 African species of the pangolin that are all found in Garamba. The park was generating decent local jobs. Local students were being supported by a scholarship program. There were mobile health clinics, and a permanent dialogue had been instituted with community chieftains and local authorities. Now here, what we saw was an ecological ecosystem and the human-made ecosystem of conventions, policies, and institutions converging in a highly effective manner. But this success relied upon another related human-made ecosystem, and that was the ecosystem of community, rangers, inspectors, prosecutors, and judges at the country level that existed to implement the national laws that had been enacted to implement a myriad of treaty obligations. Now, this ecosystem is fragile, and if one link is broken or not made, be it the ranger or the prosecutor or the judge, then the entire ecosystem collapses. And this is something that no one has better recognised than Chief Justice Benjamin. Now, I can recall very well attending conferences he organised in Sao Paulo over 20 years ago now, where the participants came from indigenous communities, inspectors, rangers, police, prosecutors, and judges and others, all interacting with one another in recognition of the fact that each one of them was connected to and in one way or another reliant upon the other to ensure treaty obligations and national laws were being effectively implemented, and that was irrespective of where they fitted in the ecosystem hierarchy. Now, these were outstanding events that reflected in very practical terms exactly what we need to do if we are to have healthy ecosystems. We need to be focused, but we need to be connected. Now, it is important to retain our focus this week on migratory species. This is a strength of the CMS, as it is with other related treaties. However, we must do so while also recognising the role of the CMS in the wider human-made ecosystem of conventions, policies and institutions, and how it relies upon the national legal, institutional and judicial ecosystem that has been developed to implement the CMS and other treaties. All right, I think I'll stop there, but before closing, I would like to take this opportunity to warmly congratulate Amy on her successful tenure as Executive Secretary of the CMS and for everything she's achieved over the past 7 years, including her extraordinary efforts to draw attention to national overexploitation, including through illegal use, and of the importance of international and national synergies, including the role of judges, in effectively implementing the CMS. So huge congratulations to you, Amy. Finally, big thank you once again for inviting me. Thank you to Brazil as our generous host, and I wish you all every success at COP15.
Yeah, and thank you, John. You would have noted that we got your last slide on. He was very worried that the last slide will not be seen. So I told him that we'll wait for the last slide. That was a great slide, but we missed you in person. Personally, I missed you I could have ribbed you about beating you in cricket, but some other time. Let's move swiftly on to Ms. Maria Jose Ortiz, who's the legal officer and head of conference services of the CMS Secretariat, and she's going to now tell us how the national legislation program is going to be useful and how it will help implement CMS obligations. Am I correct, Maria? The floor is yours.
Thank you, Vivek. And first of all, thank you, Justice Benjamin. This is a treat for me, CMS legal officer, having all these people talking about CMS species and how law can help is an honor and it's a treat. And sharing a panel with Elizabeth it's a bit intimidating, but I was very, very happy. Well, thank you. So I'm going to start trying to answer a very practical question. So just bringing it down to earth. So when a country accedes the convention, how should a national legislation look like? So what kind of provisions, how is the definition of tech needs to be reflected in the law, or which are the conditions? That's what I would like to cover, to see what we found and how countries can strengthen and maybe some steps forward on the future, and also with the decision of this COP. So to support parties in developing and strengthening legislation, the COP12 established the National Legislation Program in Resolution 12.9. The central objective is to ensure that the prohibition of taking is effectively implemented at the national level. So the Article 3.5 of the Convention prohibits that the taking of Appendix 1 species. So what it seems like a very simple sentence, at the national level, it has many elements that we need to look at. So we will be looking at how is it defined, which are the laws that are implementing, at which level, which are the authorities, what is the geographical scope, how are the species covered. So all of that is what we are looking with the national legislation and making recommendations to countries on how they can improve. So the program has two main tools. One is the analysis of legislation. So parties will submit a questionnaire that was adopted by our standing committee, and the Secretariat prepares what we call the national legislation profile. So for each party, we will identify gaps, inconsistencies, and possible improvements in national legislation. At present, there are 70 parties taking part in the program, and we have prepared legislative profiles for all of them. A second tool of the program is more on the capacity building, legal guidance, technical assistance that can go beyond the prohibition taking itself. So just a few notes on what we are learning about the analysis. So one key observation is that in contrast with CITES, for CMS, the implementation at least is spread across many different legal frameworks. So we are looking at wildlife law, hunting regulation, fisheries, biodiversity, but we are also looking at, for example, environmental impact assessment or infrastructure laws, energy laws. In the case of Article 3.5, that can be across any sector, any activity. But we are focusing for the national legislation, we focus on the definition of take in particular. So the convention defines as capturing, killing, harassing, and attempting wildlife. So what we found in the legislation is while generally countries will prohibit the take and the hunting, sometimes they are not explicitly prohibiting, for example, the harassment or the attempt. So from a legal perspective, there are some significant implementation gaps between the treaty obligations and domestic law. Another important thing in terms of definition or how they are reflected in national law is the exception of the prohibition of taking. So Article 5 do allow for taking on 4 cases: that scientific purposes, enhancing the survival of the species, traditional subsistence use, and extraordinary circumstances. But there is a second layer of criteria limiting those exceptions, so they must be precise in content, limited in space and time, and do not operate in the disadvantage of the species. So like I said, there is not a CMS law. The CMS is implemented across multiple legal frameworks, so these exceptions might be wider or looser than what the convention is saying. So for example, on issues like public interest, national interest, might be interpreted differently in different jurisdictions. So this is why the application of law and the role of the judges, I mean, authorities, civil authorities, but then ultimately administrative authorities, sorry, and then ultimately the judges and the prosecutors on how they are implementing the law, because what we see, the CMS definitions are very, very rarely just reflected as they are in the convention. So that's why I'm stressing the role of the judiciary in the implementation of the CMS. Another area of work that we've been and we would like to work more is the deterrence and enforcement. So a preliminary analysis on penalties from the countries that we have received legislation. There is a law, there is a penalty, but is it enough? Sometimes we have found that penalties are relatively low, so they do not really change behavior. So this is one of the proposals that we have made to the COP, and this morning the item was introduced, and it seems it got support from the room, is to develop a study on deterrence and penalties, and we are already advanced in talks also with UNEP, so that might be a possibility for collaboration, but I think it will really give us a lot of light on how CMS can be strengthened at the national level, even though we may have a prohibition of taking in place. Another area of work in the legislation program is the capacity building aspects of the program. So we have prepared 3 legislative guidance documents for countries. So one is the implementation of Article 3.5, another one on the application of the exceptions on the taking prohibition, and finally another one on legal tools to support ecological connectivity. We also organized last year a workshop in Bonn on legislation that brought together government representatives, academia, and legal experts. And one of the key takeaways from the workshop was the need to engage among countries, but also among different actors of implementing the law. So that's why we have proposed today also to the meeting the creation of a multi-stakeholder task force on legal matters for CMS, and we will really hope that parties will consider that this is a very useful tool for parties to exchange across countries, but also across sectors. So judiciary from several countries, they can look at how they are implementing CMS. When there is a country doing a revision of the law, they can have consultations. So it will be a pool of expertise and exchanging of experiences. So we are really hoping that this is something that parties will find useful and can support. So in closing, like I said, we can have laws, but at the end of the day, the judiciary will have a major role in implementing, and that's why we need also to engage with prosecution, judiciary, especially on enforcement matters. Thank you very much.
Thank you, Maria, and thank you all three of you, three lawyers, two besides me, one behind me, who have pronounced wonderfully on the matter at hand. As the sole biologist sitting between all these lawyers and representing IUCN and the Species Survival Commission, all I'll say is we are the intel inside, right? Our job is to give you data, and as far as the Species Survival Commission goes, 15,000 voluntary scientists are at your service, both the CMS, to which we are legally obligated as IUCN to assist, but also to the judiciary, and really hope that, Antonio, that the judges of this world look at you and take inspiration and come forward to act and lead us to a better future. Thank you very much.
Many thanks to our chair, to our two fabulous panelists. We move to the next panel, which is chaired by Rita Mesquita. Rita is the National Secretary for Biodiversity, Forests, and Animal Rights, and I could not imagine a person that is better qualified for the title. And we are delighted to have Rita with us. The two speakers are both very well known in the law community and the environmental law community. Andrew Rain, presently at the Law Division of UNEP, but as announced by Elizabeth Mirema during the opening plenary, soon in Bonn, as the new Secretary of the Migratory Species Convention. I have known Andy for, I think, 2 decades, almost. And one of the things that impressed me the most about him is that sometimes we have judges that don't look like judges, and other times we have people that are not judges, but look like judges, and act like judges. And Andy is one of those colleagues that speak with substance, but also in a judicial manner, a man of reason, and it's a great privilege to have him as a friend as well. Professor Nicholas Bryner is American, Brazilian, or Brazilian-American, depending on how we see him. And he is one of the stars of comparative environmental law, and the finest Brazilianist, the only one that focuses on environmental law. Brazilianists are Americans that study Brazil, and Nick is the finest we could have. He has written extensively on Brazilian environmental law, but also in other capacities looking around the globe, comparative environmental law in general. He's the General Rapporteur of the Model Forest Act, the product that we are almost concluding very soon. We'll end the 3-year project, but they are much better qualified than me, and they have more time to discuss the Model Forest Act. So many thanks to the three of you.
Thank you, Judge Herman Benjamin. To start, I must announce myself as a biologist, so completely out of my realm here when it comes to law. But I've lived long enough to know the value of duly applied legislation protecting nature and advancing, making progress for conservation. So I am really curious to learn more about the Model Forest Act, which is the subject of this panel. I understand that both of you have worked and been deeply involved with it. So I just want to say that it is really important that we can continuously improve the legislation, that I understand it as a process of the society, that legislation changes as society changes. But we need to keep in mind the enormous value of not going backwards, not diminishing what we have conquered. And for that, I think all our societies need to be extremely aware that we are facing tough times, that all the time we are challenged with all the progress that we have made. So I really hope that we can use this opportunity to understand how we can improve the current legislation. Because let me tell you, if you go out in the street and you ask your average Brazilian, and people have the feeling that we have very advanced, very good laws. And probably we do. But we really need to improve how we enforce the good legislation that we have. And I think opportunities like this to interact with judges and with the legal system are very valuable, because good laws without being duly applied are of no use. And we need to make sure that the good legislation that we have results in the protection that is the first objective of creating them. So without going any further and getting myself into deep waters, I will pass to our first panelist, which will be Andrew Ryan. Andrew, thank you.
Thank you very, very much, Rita. And firstly, thank you to you, Justice Benjamin, for your leadership in bringing this topic not only to this COP, but to the story of this convention, and to you, Amy, for readily agreeing to that. I'm being very, very careful in what I say at this COP. I'm just a fly on the wall. I'm not the executive secretary yet. But let me break that rule that I've set myself and say, from my perspective, I cannot think of a more important agenda to push forward with. You've done this successfully with the Climate Convention. You've agreed with Astrid to do it at CBD. It has to be here. It has to be in this ecosystem of biodiversity. So thank you for your leadership in that, and thank you to you, Amy, for helping this agenda move forward. I'm a lawyer as well, so I am not unapologetic about that, but before talking about what I'm supposed to talk about, I want to pick up on something that John said about the connectivity of these conventions and of this topic. Ecological connectivity is one of the superpowers of this convention, and huge congratulations to Amy for really giving it the oxygen that has enabled it to grow into the tapestry of biodiversity governance today. And that is an incredible gift to this convention. But one thing I'd like to add, when I think of ecological connectivity in the context of how we make it work, is that we need governance connectivity. Governance connectivity is a key enabling condition to achieve ecological connectivity. Because you can think of any migration, and unless you have coherence, legal coherence across the range states in that migration, the ecological chain can break. If one range state allows harmful pesticides, the ecological chain can break. If one range state, we're talking about judges, if one range state does not have a judiciary empowered with the capacities, even in the institutions, to enforce the laws on the books, the ecological chain is broken, the governance chain is broken. And so that's where this very exciting initiative, the Model Forestry Act initiative, steps into this story. This is a very exciting initiative to reimagine forest governance. It started about 3 or so years ago, I think, maybe longer, about 3 or so years ago, again under the leadership of Justice Antonio Benjamin, who has, in the way that Antonio does, he has brought together a constellation of the people that need to be round the table to make this happen. We have the multilateral development banks, the World Bank, ADB. We have UN entities, UNEP, UNDP, FAO. And we have other essential partners, IUCN, the World Commission on, and its World Commission on Environmental Law, the Global Judicial Institute on the Environment, and others joining this initiative, this family of committed institutions to strengthen forest governance. So, what is it? Essentially, you'll see in the materials that have been handed out a first draft of what's called a general part of the Model Forest Act. This is going to be accompanied by a legislative guide, but this general part is a model law, a framework of possible provisions to strengthen forest governance. There's 16 chapters to the general part, and I'm a double act with Professor Nick Briner today. He's going to give more detail, more granular detail about what's in the Act. But in general terms, what it seeks to do is to invite countries to look at these 16 chapters and almost like a shopping cart, go to them and say, well, yes, this would strengthen our legal framework. That would too. It's not a prescription. It's not a you must do this. It's an invitation to see what is possible. It's been developed through a drafting committee and informed by global stakeholder consultations around the world with different institutions, with communities, with indigenous peoples. All of these learnings coming into a fabric of a model law, which we hope, we think, and we know will be a tool to implement international obligations under different instruments, including CMS. So where we are with CMS at the moment, there are various entry points on how the convention can help implement the convention. And Maria, thank you for the excellent overview of the national legislation program. This is one more tool to feed into that program. A lot of forest legislation is out of date. It was drafted at a time when perhaps the primary focus was on timber extraction, long before the Paris Agreement, long before the Global Biodiversity Framework, and perhaps even those instruments around the world that are more advanced, some of them don't necessarily reflect the latest thinking and learning that we have around integrated management, around ecological connectivity, around how do you truly engage indigenous peoples in forest stewardship. So all of these are now, you'll find, expressed with model provisions in the general part of the Model Forest Act. So before turning to Nick, in the interest of time, I'll be very, very brief. Before turning to Nick, just to highlight 3 provisions that you'll see in the Model Act that are directly relevant to CMS. The first is we have included a placeholder for a dedicated principle on ecological connectivity. And this is important because principles, these are the building blocks of legislation, of law, and we've given articulation to this principle. Second, you'll see granular duties on states and on forest institutions within those states on how to put into place ecological connectivity, how to identify, how to protect. And then you'll also see a third provision in there directly incorporating ecological connectivity and migratory species more broadly into environmental and social impact assessment procedures. There are other entry points in the Model Act, and you'll see in Maria's excellent work with the National Legislation Program the raft of entry points that need to happen to give full effect to the convention, but just to give you a preview of those 3 placeholders. So many thanks for this opportunity. Many thanks again to you, Justice Benjamin, for your leadership in this process, for your leadership in the broader process of how we accelerate the role of law and judges in helping to implement vital conventions like CMS, like Ramsar, like CBD, this big fabric of international biodiversity governance. Many thanks. Back to you.
Thank you. Quite a challenge to put together such a thorough, plan. Congratulations on that. I will go directly to you, Nicholas.
Obrigado, doutora Rita. And thank you, Andy, and thank you to Justice Benjamin and to Amy in particular for helping us organize this event at the CMS COP, and to all of you for being here to listen to this conversation. So thank you, Andy, for giving that introduction. The Model Forest Act initiative has been launched 3 years ago, and together with the drafting committee, we've been working on putting together this text and a legislative guide that will accompany it, and which will be launched later this year at the CBD COP. I'm also a lawyer, and I will maybe be slightly more apologetic about being a lawyer in the sense that law is not known for being very poetic, and law is really, I think in the popular conception, is about drawing lines, right? So law is about drawing boundaries and lines about what you can and can't do, and that aspect of law really seems to fundamentally conflict with everything that we're talking about at this conference, right? The idea that there is some kind of fixed line or fixed boundary. And law regarding forests was traditionally about exploitation. Even to the extent that law was designed to regulate exploitation, it was encouraging in using that as the frame of reference. Migratory species, on the other hand, make something visible in the forest that we wouldn't otherwise see. It's because of the migratory species that we really see that forests are connected and they have that continuity. So I'm glad that you raised that concept of governance connectivity that goes along with it. So the idea of the Model Forest Act initiative is not to prescribe a wholesale redesign of any nation's forest governments, but rather to provide a model and to provide some guidelines and an opportunity to rethink forest governance. It's not a negotiated text, and so it's not limited by what has already been accomplished or the universe of what you would already see in forest laws. It's really intended to be ambitious and forward-thinking, looking beyond what has already been accomplished at new ideas and more innovative ways and more sustainable ways to engage in forest governance. And so a couple of the key components of this draft that you all have is that it begins with a preamble introducing the ways in which forests are connected to all of these other important aspects that we've discussed today, the relationship between forests and human rights, the intrinsic value of forests, and the intrinsic value of the biological diversity that's found in forests. The Act begins with the general scope and with objectives of the law that range far beyond just the idea of exploitation of resources, recognizing the forest for all of the value that is found within it. Again, it's about providing an effective legal framework that connects and integrates forest management with environmental, climate change concerns and all of these other important objectives. So it's about providing a more coordinated and more holistic approach for forest governance that takes into account the drivers of deforestation and forest degradation and is integrated with concern for biodiversity and other environmental, social, economic, and cultural challenges. And so the draft includes principles of forest law and governance like those that Andy has begun to mention, again, that are not limited to what exists in current forest laws, but taking the best of what we can find from environmental and integrated governance and putting these out as the suggestions. The idea is that a country that is in the process of reforming its forest laws or modernizing any aspect of its forest laws could look to this for inspiration with ideas of what to look at for the future, how to meet 21st century challenges. And this is the preliminary draft, and the further drafts will include more provisions, a dedicated chapter specifically on climate change, which we don't have in here, that really compiles all of the ways in which you need law to deal with climate change in the forest context. And it includes a chapter on forest rights, but not just forest rights, but forest duties, the duties of the state. The duties of the state and the duties of all of the organs that are part of the state in order to ensure that rights are respected with regard to the forest. So that's one of the forward-thinking elements of this draft. And it includes a detailed list of instruments that are used as those elements of forest governance. One other thing that I want to highlight that's part of this draft, in part because of the strong leadership of the judiciary in the development of this initiative, is that the law is intended to be drafted with implementation and enforcement in mind. That's a critical, important detail, right? That the law has to be written in a way that can be useful on the ground, and not just useful on the ground for practitioners or for foresters or people who are actually engaged at that level, the community level, but also written in a way that a prosecutor can read it and identify clearly what the obligations and duties are, and that a judge can clearly read it to provide effective access to justice. And so there's an entire chapter dedicated specifically to implementation and enforcement, as well as to access to justice. Even though those things might not have traditionally been seen as part of forest law, the point is to draw those connections, right? And to ensure that when we have a law that regulates forest concessions, or that regulates protected areas in forests, or that regulates the management of biodiversity in forests, that we're thinking about how to make this really focused on implementation from the ground up, from the very beginning, so that those obligations are clear and are understandable and predictable. And that's the intent and that's the goal, right? Is that this model act, even though no country would necessarily take the entire piece of it and plug it into their system, but would look for inspiration to these various ideas, to these various concepts. What should we be thinking about when it comes to enforcement authority, the use of technology and science? How are we giving proper authorization and resources to the forest management authorities to use satellite evidence, to use all of the new technology that we have available, artificial intelligence, and other tools that might be useful to really identify and understand what's going on in the forest? Taking that, talking about administrative enforcement, judicial civil remedies and penalties, criminal enforcement, wrapping that all together in a package that integrates all of these concepts together. And so to sort of circle back to what I was saying at the beginning, law is about, too often I think, just about drawing lines, and the intent of this act is to break that apart a little bit and recognize that forests are not just places, they're not just a piece or a jurisdiction or a line within a fence, but it's a pathway, it's a habitat for species that move across continents, and it supports human life as well as all of these various species. And law at its best should follow that pathway and connect jurisdictions just as those ecosystems are connected. And thank you.
I will just very briefly, I know you're running out of time, Judge, but I have to say this. During COP30, Marina Silva was champion a discussion on the global ethical stocktake. And that was something that got a very large dimension in the discussions during our convention here. And by just inspecting the pages where you put together the principles for forest law and governance, I can't help but think that understanding these principles are a matter of citizenship. I think every person, every student, people should clearly understand what these principles exactly mean. To me, it looks like a framework for education, for children education, because at the end, law is an exercise of citizenship. And if you don't have it, then how do you abide by it? How do you follow it? How do you put its importance? And just making the connection that these principles, to me, seem like to be directly connected to the global ethical stocktake that we so much discussed during COP30. So I'm sure to read very carefully everything that is in here, because I think that is very precious material here for reflection, for everybody to learn more about critical concepts in our environmental legislation. So thank you both for putting together, doing this effort under the leadership of the judge. Thank you so much, Judge Herman Benjamin.
Many thanks to our Secretary, National Secretary, Rita Mesquita, Professor Nicholas Briner, Andy Rain. You have noticed that I am the last speaker. And this is a technique that I use. When I am organizing an event, I put myself at the very end. I give myself 30 minutes. This time I think I gave myself 20 minutes. Because if we are running behind, then I don't speak. And that's exactly what's going to happen here today. I will use the time that was assigned to us and was used very good by the previous colleagues, just to thank again the organizers, the CMS, Amy, and your team. Many, many thanks. I know that you are surrounded by logistical problems in organizing an event like this. The same thing, our colleagues from the Ministry of the Environment. And I would like to thank Braulio, the former executive secretary of the CBD, and somebody that we all respect very much. I mentioned Andy as looking judicial, but can you imagine somebody that looks more judicial than Professor Braulio? He teaches us every day. It is a pleasure always to be with you and learn, even when we are in informal conversation. He has done so much in this country, and his modesty can be bigger than his knowledge and his generosity. So I'd like to thank you in public for everything that you do. Elizabeth Mirema, you are someone that, again, is another judge in disguise. A Supreme Court justice in disguise. She is a true believer. And I'm very proud that among her friends, I am the only one that has been to her hometown, called Moshi, at the bottom of the Kilimanjaro. The Kilimanjaro didn't want to show itself to me. I couldn't see it. I went all the way there to see the Kilimanjaro, but I was able to spend a night at Elizabeth Mirema's hometown. And Chief Justice, meu querido amigo, presidente do Tribunal de Justiça do Mato Grosso do Sul, you are the real star in this event. Você é a verdadeira estrela deste nosso evento. Porque é tão fácil nós do direito usarmos palavras bonitas, anunciarmos sonhos e simplesmente esquecermos da ação. For us judges, it's quite easy to announce dreams and forget that action is really what matters at the end of the day. Tenho certeza que esta nova vara ambiental do Pantanal dará muito o que falar, porque o Pantanal precisa realmente dos juízes guardiões, juízas e juízes. I'm sure that the new Environmental Court of the Pantanal will be heard a lot for the action that is necessary from judges as guardians of the Pantanal. On that note, we end on time. Many thanks to all of you, to the audience, to the team that was helping us with the logistics, and again to the Association of Judges of Mato Grosso do Sul. Agradecer à associação, por favor transmita ao presidente a nossa gratidão pelo apoio. This is the first we have done, as Amy, Elizabeth, and others, and Andy have said, but it's just the first of many other law gatherings within the umbrella of the Convention on Migratory Species. All the best to you. Great success with the COP. I have to return to Brasilia immediately, but it has been a great pleasure. Thank you very much.